Well, welcome everyone who's joined us this looks like clearing afternoon. Thank you for joining us. This is our third, maybe our fourth installment. Uh, the purpose of these webinars is to try to get some more information based on out into your hands, our clients' hands, and anybody else who might be joining or viewing to try to demystify the process of estate administration. We'll touch on a few estate planning issues as well, but today we're going to continue discussing some estate administration issues. I get a lot of questions when I sit down with my estate planning clients. Typically, they'll come in, and one of the first things on their mind will be, listen, whatever we do here, I want to make sure we don't have to deal with probate in the event of our death. And so I thought what we'd do today, Sarah Smith and Per Oscarrson, other members of our team, are going to join us and discuss what probate is, when it's required. Sarah will handle those issues. And then Per will talk about alternative forms of administration or administration techniques that don't require probate. But before we turn to Sarah and Per, let me just remind you, really what we're talking about here is the process of estate administration when somebody dies. There is always a need to conduct some form of estate administration when somebody dies. The steps that you have to go through or the process that you must follow differs. Probate is just one form of administration. There are four components that must always be dealt with in every estate administration. I know I've said this in each of our prior webinars, but let me remind you. Whenever somebody dies, the following four steps must be accomplished in one way or the other. First, we have to figure out who's in charge. If there's a will, often that person is an executor. You might hear us refer to the term personal representative. Those are synonymous terms. If an estate has been organized around a trust, that person in charge will be the trustee, usually the successor trustee. If there is no trust or will, then the person who gets nominated to, or appointed, I should say, to conduct the administration, we refer to them as an administrator. So first we got to figure out who's in charge. The second step is we have to gather the assets. So gathering the assets is usually fairly easy when the estate's been organized around a trust, because the trust typically will own all the assets and therefore already be under control of the successor trustee. When there's not a trust, however, or when there's a trust and not everything is owned by the trust at the decedent's death, then there's need for somebody to be able to gather control of those assets so that the second and third, or excuse me, the third and fourth steps can be followed. The third step in every administration is to pay the bills. Sometimes that involves getting notice out to the creditors, sometimes it doesn't. But that third step must be followed. We've got, either with notice or without notice, we've got to pay all the bills of the estate that are due. Once the bills are paid, then we have what we refer to commonly as a net estate available for distribution. Now, what we're talking about today is, when do you need to go through probate to accomplish those four steps? And when don't you need to submit the estate to probate? And remember, I've talked about this in the past, probate is just the judicial oversight of those four steps we discussed: determining who's in charge, gathering the assets, paying the bills, and then distributing according to the will, the trust, or if no will or trust, according to the law. Probate is just the judicial oversight of those four steps. So sometimes probate's required to accomplish one or more of those steps. Sometimes it's not. So Sarah's going to talk to us a little bit about when probate is required. She'll probably have a comment or two about the process, but this is intended to be a process-heavy discussion. It's really intended not only for those of you who might be involved in an estate administration or may become involved in an estate administration in the future, but even for those of you who are doing some estate planning. if you're thinking that you want your planning to be geared around avoiding probate, I think you'll find this discussion helpful as well. So Sarah, why don't you talk to us a little bit about probate and when it's required?
Mhm. So the first thing that's worth discussing is clearing up a common misconception. It is frequent that people will come in and they'll have questions and they'll say, well, I'm the personal representative according to the will, and how do I do this? And the practical reality is that you may be nominated to be the personal representative under the will, but you are not in fact appointed until the court appoints you and gives you that power to act on behalf of the estate. And this is evidenced by receiving letters, either letters testamentary if there's a will, or letters of administration when there isn't. This is incredibly important because without those letters, without that court appointed power, you are not able to act on behalf of the estate where necessary. While this can often be necessary where you have financial institutions or banks that want proof of permission to work with you because of an asset that was held solely by the decedent, um, or because of the nature of your assets, either the type or the value may be so high that some of the alternative methods that Per will go into later may not be available. And probate will become the only option for making sure that the title to those assets is transferred appropriately and cleanly to the beneficiaries or heirs of the decedent.
So Sarah, sorry to interrupt. When you're talking about assets being controlled by the financial institution, you're talking about a checking account, a savings account, a money market account, maybe CDs, those kinds of things?
Mm-hmm. It could be a
Yeah.
safety deposit box, anything that isn't going to transfer by other means, whether it's a payable on death designation or controlled by perhaps a community property agreement or some other tool that we can use as an alternative.
So you mean to say that somebody has died and you walk into their bank and you show them that you're nominated in the will to be the executor, the bank won't just hand over the money?
Unfortunately, no. They're going to want proof because otherwise they're going to get in trouble later, and they don't particularly want that. They'll want something from the court saying that you absolutely have the power and authority to act on behalf of the interests of the decedent or the decedent's estate.
So I think you mentioned that form is something called letters. Where do you get the letters? How do you get those?
So when you initiate the probate process, you will essentially submit the will, or if there isn't a will, submit the appropriate paperwork accordingly, and request that the court grant a person or persons authority to act on behalf of the estate. The court will then review the information and grant permission, and as part of that process, present you with letters upon filing the appropriate oath to act in that fiduciary capacity.
So the letters are something that the court issues if to the person they've appointed to be the executor of the estate.
Precisely.
Got it. Okay, thanks.
Uh,
Is there any other way to get letters besides opening probate and getting the court to appoint the executor?
no,
Yeah.
not letters testamentary, letters of administration. You need court approval in order to receive those. And some institutions will not be satisfied by any other form of authority.
And so if those institutions are not satisfied with anything other than letters, does that pretty much dictate that your only choice is to go start a probate and get somebody appointed?
Generally, yes.
Yeah. Okay.
There are some situations, you touched on trusts and other alternative methods, but trusts in particular can be a dangerous thing because if it hasn't been kept up and the assets haven't been transferred in, you may still need probate to transfer them into the trust. You can find out that you thought everything was titled between you and your spouse, but oops, something was missed. So there are just necessary times where you do need to have this appropriate authority.
So is it fair to say then that whether you go to a bank or maybe an investment broker or something, and you ask, how do we gain control of these assets of the decedent so we can further the administration? And the response is, well, one of the things we need letters of administration or testamentary letters. That's the reason we have to go start probate. It doesn't have anything to do with the value of the asset or any other consideration. If the institution or third party in control of the asset requires letters, and if we can't find a workaround for those letters, then that forces our decision to commence probate. Is that fair to say?
Correct.
Yeah.
Those are sort of two separate issues, one of which is the financial institution going to require it to work around a specific asset? Another is, do you have such quantity of value of probate assets which transfer subject to the will or intestacy laws, that you cannot transfer without opening probate? For an example, there's such a thing as a small estate affidavit, as it's commonly called, where if you have these probate assets, but they're low enough in value, you can use this affidavit as a bit of a workaround. And I suspect Per will go into more of that later. Those are the sorts of situations where you will need this authority to deal with the assets at play. And it's not always about assets. You may have a litigation situation where litigation was either ongoing when the decedent passed or is brought up perhaps later, and somebody needs to be granted court authority to act on behalf of the decedent's estate, decedent's interests. Again, this is the necessity of having somebody appointed to stand in that person's behalf. There are just some situations where you can't get around that. And this is where probate becomes necessary.
So you need an appointed executor to deal with the gathering of the asset phase of the administration. But you're saying you may also need, or even if you don't need an executor to gather the assets, you may need a court-appointed executor to deal with paying the bills portion of the administration.
Mm-hmm.
In terms of if a creditor comes out of the woodwork, submits a claim that the estate executor doesn't agree needs to be paid, and there's a lawsuit, the only person authorized to represent the estate in that lawsuit would be the court-appointed executor, right?
Correct.
So
Correct.
sometimes creditor issues will dictate just as much as asset gathering issues would dictate the appointment of a court-appointed executor, and therefore a probate form of administration. Yeah. Okay. Great.
Exactly. If there are disputed creditor claims, or even it could be something as simple as if there are issues regarding the identity or nature of the decedent's assets or heirs, or who should take under the estate. If there's any real question of law that can't be dealt with by the estate planning that was done prior to the decedent's death, this is unfortunately where the probate process may be necessary to clear up these issues of fact.
Yeah. So that'd be the fourth point of administration, the distribution section. You're really saying there are times when you need a court-appointed executor through a probate to deal with either the gathering the assets or the creditors or even the distribution phase.
Exactly.
Could be a need for a court-appointed estate representative at any point along that process.
Exactly.
Okay, great. Well, Per, is probate always necessary? And if not, when not? Do you have any thoughts about that?
The answer is no, it's not always necessary. But even with some of the other options that are available, they may not be a complete replacement. So it may be necessary to also do a probate. Sarah had mentioned the small estate affidavit, and there's potentially an exception to that investment account holder where they say, well, we need to have letters testamentary. If you've got an estate where the net value is under $100,000, you can use this small estate affidavit. It only applies to personal property. So if there's some real estate involved, although if the entire estate is under $100,000 net, including real estate, then you're probably gonna be okay, but you've still got issues with the real estate. And again, this is looking at the net value of assets that are subject to probate. So if you've got that account with an investment firm, for example, and it has a beneficiary designation, that's not normally part of the probate assets. So it wouldn't be included for purposes of determining whether you've got an estate that would be administratable under a small estate affidavit.
So why? Let's say that somebody's got a $500,000 account at Edward Jones, and that account has pay on death transfer designations. are you saying that a small estate affidavit could still be used even though that one investment account is 5 times the amount of the small estate affidavit?
If the beneficiary of the account is a third person, and hopefully the contingent beneficiary is not the owner's estate, because that may put, if the primary beneficiary has died, that asset is no longer a non-probate asset. It's become a probate asset, and now we, as you say, we've kind of blown ourselves out of the water, because now we got a $500,000 asset that's subject to probate. If the primary beneficiary is still alive, it would not be included in that calculation.
I see. So if the asset would transfer by virtue of beneficiary designation, it sounds like that's not considered to be a probate asset. And so it would not count toward that $100,000 small estate affidavit limit. Is that
correct?
Correct.
Correct.
Okay. And so let me ask you this. This is a little bit off topic, but some people might have a question. Let's say there's a will that leaves everything to a surviving spouse, but there's the same $500,000 investment account, and the pay on death beneficiary is not the surviving spouse. Instead, it's the decedent's brother or something. Does the will govern, or does the pay on death designation govern generally?
Generally, the pay on death designation should govern. There are some things with super wills, which is kind of outside our area too for today. Under certain circumstances, there may be some types of accounts where you can provide that the will govern it, and that it was intended all along for the will to govern it, but that won't apply to all types of accounts.
So it sounds like there's a distinction essentially between probate assets, or assets that will be distributed according to the will, or maybe a small estate affidavit.
Yes.
Versus non-probate assets, which will be distributed according to some kind of transfer or payable on death beneficiary arrangement that was made by the decedent.
Correct. Yep.
All right, good. All right, thanks. Hopefully.
And there are other requirements. You can't use it within 40 days of date of death. It can only be provided by a successor as defined in the statute. That could be a spouse. It could be someone else. And the other thing is, and it certainly makes sense, since this is intended as an alternate to, or an alternative to probate, that there cannot be any pending probate or any application pending for the appointment of a personal representative at the time that it's used. Another thing is a lack of probate affidavit, which I think is probably used more often involving real estate than personal property. But in that case, of course, no deed is recorded, but the lack of probate affidavit would be recorded, so that when for example, the surviving, if it's a surviving spouse that was having it, or actually any other joint owner, if they go to sell the property, now this lack of probate affidavit shows hopefully that the surviving owner of it, or the beneficiary who would have received it had there been a probate, actually is entitled, and so that title insurance can determine that there is a proper chain of title. So they would insure title when that property eventually is then transferred by the recipient.
So Per, if there's something called a lack of probate affidavit, which by its name sounds like you don't need to do a probate, why don't we just always administer an estate by a lack of probate affidavit? Why do we need to go to probate at all if there's something called, or a technique called lack of probate affidavit?
Well, you still end up with the situations like Sarah was talking about, where there's something in the probate that might still require that probate be done. And it could be any number of things, whether it's the type of asset, the value of the asset, someone saying, "Hey, we're not going to work with you until we see the letters testamentary or the letters of administration." Although just this morning I heard about a company that they talked about letters testamentary, and then I discovered that what they were talking about was a form that they have that is not, and it's more like, I guess it's more like a lack of probate affidavit, because it has some of that information in it, but it doesn't give the authority to anyone like letters testamentary or letters of administration issued by a court. Right. But it is kind of disconcerting when you hear there's another form out there that's not issued by the court, somehow given a name very similar or identical to it, And people just going to throw that out there and go, oh, we're good. We can get this one from this company. And we'll just fill out that form.
Yeah.
It's not quite that easy.
So, hey, Per, talk to me a little bit about trust administration. Is probate necessary when you've organized around a trust? Is it ever necessary? And I get a lot of questions about, well, if I'm organizing around a revocable living trust, why do I need a will?
Okay, well, I'm going to give you the answer that I would normally give people, which is it depends. Because sometimes the trust is created by an attorney, and I have seen where the attorney, that's all they do. They don't put anything into the trust. But their client thinks, hey, I've got a trust, great, I'm all set. Comes to the end of their life, or hopefully long before that, and they discover, oh, I have a trust, but there's nothing in it. And so if there's nothing in it, there's nothing for the trustee to administer upon death. And now, if there's no will, now you have an intestate administration, potentially with the court, unless there is something else that can be used, like a small estate affidavit or a lack of probate affidavit, to deal with those items. Sometimes I have seen where the trust is initially funded, but as people go along and acquire additional assets, they may or may not acquire them through the trust. They may acquire them personally, and then they never get transferred to the trust. So if that happens, and if there is a will, but the will does not, as we call a pour over will, which would put whatever they have that's not in trust goes into the trust, that's great, because that should take care of the issue. But if it doesn't, if their will, if there is one, does not pour over what they have or may have outside of the trust into the trust, there may still be a need to probate.
So would it be fair to summarize it this way? At death, any assets owned by a trust generally do not require probate to follow the trust instructions regarding distribution. But any assets not owned by the trust at death may require probate of the will if the will provides non-probate assets should be funneled through the trust. Is that a fair way to summarize?
I think that's a fair way to summarize it, yes.
Okay.
Yeah.
So it sounds like you need a will and a trust if you organize around a trust, just in case you have any non-trust assets at death, because the will, that's often referred to as a pour over will. Is that right?
That's right. Yeah, it's a very good idea.
And the pour over refers to the pouring over of non-trust assets into the trust. And sometimes a probate's required to do that. Is that correct?
Right.
Unless one of the exceptions that you're discussing should apply.
Right.
Yeah. Okay. All right. Good. Good. By the way, folks, before Per continues, I just want to alert you, if you've got questions, submit them, and we'll do our best to answer them at the end of Per's comment.
Another thing that's useful, and it's a fairly recent development in the state of Washington, is a transfer on death deed. Those came into effect in 2014 in the state of Washington. I think they were in effect in other states prior to that. It's kind of an unusual thing, because when a person grants a transfer on death deed, it looks a lot like a deed. If we were just involved in buying and selling a piece of real estate, there'd be a deed. Well, this deed looks an awful lot like it, except it says it's intended to be effective only upon death. It does not transfer any interest in the property prior to the grantor's death. It doesn't give the potential grantee any rights in the property prior to the grantor's death, and it can be revoked. There are, unfortunately, at least for the grantee, typically they would receive certain warranties when they receive a title or a deed to a piece of property, particularly if they get a warranty deed. There are certain warranties under law that go with that deed, whether they're stated in the deed or not. There could be a bargain and sale deed, which has more limited warranties. Things like a quitclaim deed don't provide any warranties, and the transfer on death deed is more like the quitclaim deed, because there are no warranties that go with with that deed. There's also, when the deed is recorded, typically there would be, unless an exemption applies, there would be real estate excise tax that would be applied to that transfer. One of the things with the transfer on death deed is you don't even file a real estate excise tax affidavit at the time that you record the deed. That isn't done until the grantor of the deed dies, and the grantee then submits a real estate excise tax affidavit and usually a death certificate for purposes of the recording, but they also then claim that exemption because there is an exemption specifically in the Washington Administrative Code for transfer on death deeds.
Okay, so it sounds like if, while alive, a grantor owns a piece of real property by virtue of a transfer on death deed and they've designated a beneficiary, it sounds like effectively it's no different than naming a beneficiary of a life insurance or pay on death beneficiary of a investment account or something. That property would not have to go through probate is what it sounds like you're talking about, because the property would transfer on the death of the grantor to the intended beneficiary by operation of the form of deed and law.
Correct.
So that kind of property wouldn't have to go through probate.
Right.
Hey, let me make a couple of general observations here and see if you guys agree. When I meet with a client for the first time and somebody has passed and the client is nominated to serve as the person in charge or the executor, one of the first things I'm trying to do is understand the nature of the estate to see if probate is even necessary. Is that one of the first objectives you guys have when you meet with a new client? Are you trying to determine what form of administration is required, in other words, whether probate will be required or not?
I get that on occasion from clients, particularly if they're talking about wanting to have a trust.
I'm asking about what you're doing as the lawyer interviewing the client. You're trying to gather information about the estate,
right?
Whether you're going to have to go through a probate administration. But that's one of the first things I'm always doing. Is that the way you guys approach it too?
Yeah, I think it's the best way to do it, because there may be some things that because of how the property is held, that's going to affect, if you're doing a will, it's going to affect, do you need to make any provision in there for it? And I always like to talk to people about if they've got those non-probate assets, and if the distribution is intended like equal distribution among people, when everything is considered, they have to take into account, do we have some of those non-probate assets? And how would distribution of those non-probate assets, like a payable on death account or a transfer on death account, how would they impact transfers under a will in order for that goal of equal distribution, considering everything, to be taken into account?
Yeah,
because they can really change how you draft a will.
Yeah, that's a great point from the planning side, but also from the administration side, right? One of the other things I'm always trying to do right up front in a new administration is figure out what assets are going to be transferred by the will, and is there anything about the nature of those assets that will require probate, or do all the assets in the estate have some form of probate avoidance feature? Are they all going to be transferred by transfer on death deed? Are they going to be transferred by pay on death designation, and perhaps rendering the need for probate or rendering no need for probate, I should say. So that's also one of the very first things I'm trying to figure out. Remember, we always have to go through the process: who's in charge, gather the assets, pay the bills, and distribute. But to figure out whether probate is necessary is a whole nother set of considerations that basically, as Sarah indicated, are centered around whether there's a third party like a bank or an investment broker, maybe in the case of real estate, a title company, who might be asked to issue title insurance. We're always trying to figure out whether such third parties would require letters testamentary to do what we want them to do: turn over control of the assets to our executor, ensure a transfer of real estate, et cetera. So often the probate decision is dictated by what I'm referring to as third parties in charge or in control of the estate assets.
Mhm.
Yeah,
Which ties in nicely to one of our prior webinars. When people come in, it's so incredibly helpful to bring in the will, copies, or an idea of what the assets are and what the state of the situation is going to be, so that we can quickly and efficiently gather the information necessary to make these kinds of determinations.
yeah, yeah. So if people are unsure about, let's say, the financial assets in an estate, if they're unsure about whether there's a transfer on death or beneficiary designation of some kind, how do they figure that out?
Best way is to go back to the issuer of the account, if you will, whether it's an investment firm, the bank, and ask them for the copies of the documents that were used to create the account or to make changes to the account, because those are the documents that will tell you, is it a transfer on death? Is it a payable on death? And if so, who are the beneficiaries?
Will the bank?
Because that could also change things with, if the primary beneficiary is a third party, who's a contingent beneficiary? Because if that's also a third party, we've got a non-probate asset. If that's the holder's estate, we're back to having a probate asset.
Yeah. Will the bank just hand out that information upon request?
I think if it's to the owner of the account, I don't think there should be any problem. I mean, if you're not the owner, you're going to need to have something that shows you've got authority to act on behalf of that owner.
Yeah. Sometimes what I do, especially when I'm meeting with a client for the first time, is I'll ask them to gather some information before the meeting and bring in, for example, copies of the bank statements or the account statements, because sometimes I'll find there's an indication of a transfer on death provision. Not always, but sometimes there's an indication of the transfer on death on the account statement. More commonly, this is a non-probate method of transfer, a pair that you didn't have a chance to get to, but more commonly, if a financial account's held in joint tenancy with right of survivorship, that designation is often indicated on the face of the statement. So looking at the face of the statement, if we can't tell whether the asset's a probate or non-probate asset, looking at the face of the statement, we're pretty, and the person, there's no other co-owner of the account who can get information from the institution about the nature of the asset. Commonly, that tells us we're going to have to consider opening a probate, because the authority pair that you mentioned is the letters testamentary that usually the bank or the financial institution will require before they even talk to you about it, before they give any information.
Yeah, true.
Hey, Sarah, let me ask, are there any questions? Has anybody submitted any questions we can respond to?
Let's see. A couple of comments, one from Dick saying, explain that if selling the property, you can arrange for insurable title with a non-probate affidavit, then distribute the proceeds to the heirs without probate. And also a comment from Dwight, panelists, check your firm's form for a TODD. The TODD has been problematic for title companies. I witnessed one prepared by a lawyer who had good intentions creating a deed form that was titled Transfer on Death Deed, but failed to contain the statutory required phrase that the deed does not take effect until death of the grantor. I was not willing to assume the risk to rely upon it, and unfortunately the grantee was not the intested heir. I tell people to use a standard quitclaim deed form, though there are no warranties by statute, even if a statutory warranty deed is used.
Yeah, great context, Dwight. Thank you for that comment. And sounds like it's based on your experience. We've had the same experience. The transfer on death deed really does need to follow contain all the appropriate language to be effective under the statute. So thank you. And then Per, I think Dick was asking a question about how the lack of probate affidavit actually works. And it sounded like from the context of his question, if the only asset in the estate otherwise subject to probate is a piece of real property, and we find out a lack of probate affidavit is appropriate, it sounds like he's asking, how does that process work to effectively convey the title to the real property?
I think that it actually shows up when the recipient then or the successor then goes to transfer the property, and they're the one now signing a deed to transfer the property. And it may be one or more that are at that point then going to transfer the title to the property, and they would then receive the proceeds from that.
Well, let's back up a little bit. I think
Yeah.
the context of Dick's question was, if a title company will approve the use of a lack of probate affidavit in connection with a particular piece of real property, essentially the lack of probate affidavit doesn't become a transfer deed, because title ownership is not transferred by a lack of probate affidavit. It merely is used to create insurable title. So if we prepare and record a lack of probate affidavit, that will create insurable title to the lawful heirs or successors to the estate. And if they want to turn around and convey the property thereafter, they've got insurable title so that their buyer can get appropriate insurance for the subsequent conveyance there.
Right. Yeah, because looking at the chain of title, the heirs would not show up. But having that lack of probate affidavit, I think, allows the title insurer to say, okay, we can say that the chain of title goes through these folks, and they can transfer insurable title.
Sure. So if for some reason we check with the title company and the title company says, no, we won't accept a lack of probate affidavit in this case, there's some issue associated with the chain of title, then we know that we'll need to start a probate, appoint a personal representative, and then the personal representative, in distributing the property to the lawful heirs, will sign a PR deed or a bargain and sale deed, or maybe a quitclaim deed to distribute. So the point of probate would be to legally authorize the personal representative to ultimately sign the transfer deed. And when the title company will accept the lack of probate affidavit, then the lack of probate affidavit will allow the lawful heirs to reconvey the property without the need to appoint a personal representative to issue title to the heirs.
Right.
By a distribution deed. Okay.
Yeah.
Hopefully that's all clear as mud to everybody. We're getting in the weeds here a little bit. All right. Any other questions, Sarah?
Not yet.
Okay. Well, we've come to the end of our time. For anybody who's watching, we do intend to put on one of these webinars once a month. We will stray, believe it or not, from the estate administration issues, but I do think we have one more round of estate administration issues to discuss. We do intend to address some estate planning issues as well in future webinars. So thank you for joining us. Hopefully we found it helpful. If any of you have follow-up questions for Per, Sarah, or I, feel free to call or email us. We'd be happy to do our best to answer your questions. Thank you again for joining us, and we look forward to seeing you next month.